So good afternoon, everybody. Welcome to the Real Estate Rundown for April 11th, 2022. Today we're going to be talking about don't get sued, mistakes agents make that end up in court. There's going to be a lot of, hopefully a very educational program. I think it's going to be an interesting one. There's a lot of things that we're going to talk about. So as always, I want to stress one key point. Presentation is not designed to give any kind of specific legal information. Nothing I say here is legal advice. You're going to want to talk to an attorney about anything we discuss here and how it affects you. This is general information about the topic. Most information I took for today came actually from court cases, but court cases can depend a lot on specific facts. So what happened in one case doesn't mean that's what's going to happen in yours. And that's something I stress a lot with people. I want to stress that particular here. All right, so a little about me, as always. I'm admitted in Florida as well as New York and New Jersey. I'm admitted in 3 federal courts. I handle probate, I handle business law, real estate law, and title. I've been doing it for about 10 years. I've been in closing rooms in New York. I've been in closing rooms in Florida. I've been in closing rooms in New Jersey as well. I've represented lenders, banks, buyers and sellers. I've represented commercial and residential purchasers and sellers as well. We've really covered the gamut on real estate, and we continue to. So what you're getting here is not just bit of experience. It's a lot of experience on pretty much every side of the real estate transactions. About my firm, Rosenthal Meyer is myself and Matt Rosenthal are the 2 attorneys in the firm. We do real estate law as well as title. We do estate planning, Medicaid planning, probate, and business law. What that means is we have experience dealing with a lot of the issues that realtors see that come up, and we're able to advise them. That's one thing that we are able to do for realtors that we work with, is we have a lot of advice that we can give on questions as they come up, whether it be about just the real estate law in general, but or dealing with trusts or Medicaid issues or even probate and business law. There's a lot that goes into it, and these are things that we can assist with. Excuse me. For real estate agents and teams, you do a wide range. We have a wide range of services, including, like I said, education. Here we are, right? We provide legal support. We answer questions all the time. We are basically a private legal hotline. And then we have a nice meeting space. We have a large conference room that's open for meetings. We have a small conference room that's open for more intimate trainings and client meetings as well that we make available to realtors. Upcoming events, we're changing it again because there have been a lot of questions. So May 9th is now going to be on post-occupancy agreements and probably on appraisal contingencies as well. We'll talk about that a little bit today as well, but keep an eye out for that. That's going to be a bit of a change. There's a lot that's going on with post-occupancy right now. We'll be talking a lot about that. On June 13th, Matt Rosenthal, the other attorney in the firm, is going to be talking about what realtors need to know about trust, powers of attorney, and ladybird deeds. That's going to be a really good time. That's going to be a very interesting presentation, I think. And then on July 11th, we have Michaela Walker from the Carrison Group. She's going to be speaking on social media marketing. She is amazing with TikTok. She's getting me clients on TikTok already. So I'm going to highly recommend that for people. She'll talk about TikTok. She'll talk about a couple other things. We'll probably solicit some questions ahead of time for that, just to kind of help her focus on what people want to know about. We do the second Monday of every month, so look forward to you can put that on your calendar from now. Upcoming, we've got Chad Kraft from Emphasis going to be talking about personal branding. We've got James Groves from Hole in the Wall Drywall Repair going to be talking about what selling agents need to know about repairs. We've got some really good presentations coming up, and we're working on one now on divorce and how that affects things. So there's a lot that's coming up. I think it's going to be a really good time. So we're going to dive into a couple of things. First, we're going to talk about what is a lawsuit, and then we're going to talk about why realtors get sued. And then we're going to talk about something really specific, cars and driving. And I want to spend a little bit of time on that. That's a big issue that a lot of realtors don't think about. And I want to spend a little bit of time on that one, just kind of going over that as well. So let's start with what is a lawsuit. A lawsuit is a court proceeding. It is in front of a judge, sometimes in front of a jury, but not always, right? It is not just a hearing. It involves discovery, depositions. There are usually hearings before the trial. There are pretrial hearings on motions, on evidence. Um, very little gets done at the trial except for the actual trial, right? So what evidence will be allowed is usually determined before the trial happens. Unlike what you're going to see on TV, though, trials can take years. Absolutely can take years. So a trial will sit over you for quite a while. Most of it settles though, in part because people don't want to wait that long. But most of it does settle. But trials can take a significant period of time, especially right now. Orange County is a little bit behind. Um, all the counties are behind, but Orange County is a little bit worse right now, from what I'm told. But that is just something to keep in mind, is that what we're talking about are things that could take quite some time. Sometimes they're quick. There have been trials that have been done quickly, but sometimes they can take quite a while. So what gets agents sued? There are three big things that really get agents sued: failures to disclose, contract issues, and escrow issues. All right, and we're going to break each of them down. But failures to disclose are property issues sometimes, but other things as well. Failures to disclose about your relationships. Contract issues are, issues in the contract, and then escrow issues. Escrow issues are really going to be when you're holding the escrow. This is a good reason for you to have the title company hold the escrow, but we're going to talk about that. What's failure to disclose mean? Property condition issues is a big one here, okay? If you know of a property condition, or you should know about a property condition that affects the sale of the property, you have to disclose it, okay? Agents have been sued for this because they knew or should have known. By the way, this isn't just sellers agents, buyers agents, not just listing agents, but the buyers agents have been sued as well because they should have known. If you go in and the house smells musty and you should feel, and it smells like it's got mold, and you should have known that, you are at risk of getting hit there as well. Okay? Buyers and sellers agents, if they knew or should have known about a property condition issue that would affect the value of the sale, they are at risk. Okay? Sellers agents have a bit of extra liability here, though, and I'll tell you why. If the property condition report comes back and you learn about an issue, say mold or a bad roof, and a future buyer comes along, you will have to disclose that. A future buyer coming along, if the first deal falls through, you will have to disclose, okay, but we have this issue and you need to know about it. Something to keep in mind. That is part of how this all works. Property condition disclosures have to be disclosed. That includes if you are the buyer's agent and you learn about something, if you are the seller's agent and the inspection by the buyer doesn't pick it up. All right, you have the liability there also. Another big thing that comes in on failure to disclose, though, is when you have representation issues. Okay, failure to disclose that you're representing both the buyer and the seller can be a real big issue, and this is where your listing agreement is hugely important. Okay, if you even think you're going to be showing the property, make sure you have a transactional broker agreement. Otherwise, you've got disclosure issues and you're going to have to go back and amend it, and you could have a problem later on. If you even think you're going to show the property, get a transactional broker agreement signed. 100%. That's not a thing that I'm going to tell you is a best practice. It's a must do. Okay. You absolutely need to get that because there's fiduciary duty rules and there's other rules that are going to come into play, and you have a big risk there. Could you have gotten somebody more money for the house? Could you have gotten somebody the house for less money? You have access to a lot of information, and that's going to be where it comes into play. Contract issues. I'm going to spend a lot of time on contract issues today. It's a couple of slides, but I really want to focus on a couple of things. The first one is the contract clauses added by realtors. And the second is realtors attempting to interpret the contract. Okay, let's start with the first one. What is a contract clause added by a realtor? That is, anybody knows that, there's on the contract, there's additional terms. Realtors write things in all the time. Be very careful what you do there. Be very careful what you do there. Let me tell you, I get phone calls sometimes two, 3 times a day from agents who are either reading a contract and want to know what a clause means, or who are writing a contract and want to know the language to put into a clause, for appraisal contingencies, for post-occupancy contingencies, for just generally additional terms. People are not using the appraisal contingency or the post-occupancy contingency addendums. They're not using those. They're coming up with their own. And one, we're going to talk about that next month, but two, that's going to cause some problems. Okay. The other place that realtors get into a lot of trouble is attempting to interpret the contract, and we're going to talk more about that in a minute. Let's talk about contract clauses added by realtors. If you put a clause into the additional terms and it doesn't do what you think it does, you are at risk of being sued. Okay, you put that contract clause in. There's risk to you there. All right. For example, I saw a contract recently where the buyer and the seller, on a cash transaction, the buyer was going to do a lease back post occupancy, 3 months. The rent was in the additional terms. It was, we'll say, $2,500 a month. The security deposit was in the additional terms. We're going to say it was $1,500 a month. Obviously, I'm changing the numbers a little bit. And it was in the additional terms. Buyer agrees to lease the property back to sellers for 3 months at $2,500 rent with $1,500 as security deposit. We get ready for closing day. The buyer sends over a lease. Fine. Sellers don't want to pay for the lease. They don't want to sign the lease. They don't want to pay for the preparation of it either, preparation of a better one either, but they don't want to sign the lease. They also don't want to do the application. They also don't want to go through do the credit check that the buyer is now asking for. They don't want to be subject to any of that. Do they have to? Not one bit. There is a lease drafted in the contract when they said that the seller will be renting from the buyer for 3 months for this amount of money, and with this security deposit, you have a perfectly valid lease. Who drafted that? The buyer's agent. If there's a problem in 2 months, where's the liability? The buyer's agent. Most leases have language about what to do with holdover. This doesn't. So if they decide not to leave when their lease is up, what happens? The buyer's agent is the one who's in trouble here. Why? Because the buyer's agent drafted the contract. The buyer's agent drafted those terms and put them in. You want to make sure, if you're doing this, if you're drafting terms, call your attorney. Call an attorney and say, hey, I have a question. I need a little bit of help. I need to know what this says. I send terms by text. I send terms by email. People shoot me questions all the time. It's going to protect you. Make sure you know what those terms need to say. This is to protect you. Same with appraisal clauses. We've got one now where where the buyer and seller agreed to an appraisal contingency that if the house appraises for less than market value, they'll go in, they'll pay X and X above the appraisal value, and that's what the new sale price will be. Came in a lot lower than anybody thought it would. Now the sellers don't want to accept that amount. They think they can get more. But because it's not appraisal contingency or not using the addendum, it's in the additional terms, you interpret it differently, and it doesn't give anybody any wiggle room. So again, who's at fault there? That's going to probably be on the listing agent, the seller's agent, because they didn't invite because of their acceptance of it. If that becomes an issue, that's going to probably be the seller's agent, because the buyer's agent did the right thing. Their side is happy with the deal. Another place that realtors get into a lot of trouble is attempting to interpret the contract. Again, have a lawyer ready to talk to you. Have a lawyer on retainer, or just have a lawyer who you trust, who you can call and say, hey, this is the terms, what should it say? because you want that interpretation. You want to be from a lawyer. But people interpret a lot of the contract. It's not just the additional terms. Realtors get into a lot of trouble with what is collected, what is time, right? Interpreting when things need to be done, interpreting when provisions of the contract are coming due, interpreting what the contract means. Just because it's how you've always done it doesn't mean that's what it actually is. Remember, the contract changed a little bit as well. Realtors attempting to interpret the contract for their clients run the risk of being wrong, getting their clients sued, and then facing a lawsuit. Okay. Most of the time when these contract issues come to light, it's when the other side sues your client. And then they come after you. All right. That's what you're looking at. The other side is going to sue your client and they're going to come after you. Could it happen just because they're not happy with you? Absolutely. But generally speaking, that's where this is going to come from. So keep that in mind. That's a real big risk. What else gets realtors sued? Escrow issues. Let's talk a little bit about escrow. I'm going to back up for a second, just kind of go over escrow. One of the options for escrow has always been and is still that the real estate brokerage holds the escrow. A lot of brokerages, if not all of them, have escrow accounts. And one of the options is that the real estate brokerage holds the escrow. And we've dealt with some brokerages that like to hold the escrow. That's how they know they're going to get paid. There are some real estate brokerages out there who like to hold escrow. Now, in addition to that, let's add that some realtors like to hold the escrow because if the buyer cancels the deal and forfeits the escrow, part of the escrow goes to the realtor. The seller is entitled to a portion of the escrow. That's usually in a listing agreement, and that's usually an agreement that they've come up with, but that is a possibility. That is part of why when I say some realtors like to hold escrow, that's part of why. So there's two ways realtors can get in trouble. And the first one here is if there's a dispute between the buyer and the seller and you're holding the escrow, you will get sued, okay? Now, you will be sued as the nominal defendant, usually just because they need to sue you because you're holding the escrow, and the court will need to place the order to, eventually order you to do something with the escrow. But you'll still have to show up. You'll still have to kind of defend yourself. It is still court. It's still an issue. So if you are holding escrow, something to consider is you are opening yourself up to lawsuits where you may have to pay for the attorney to represent you. You will probably need an attorney to deal with some of it, but you will probably be the one who needs to pay for the attorney to represent you to handle the escrow. Okay. One of the reasons to not hold escrow is because at some point you could be sued just because there's a dispute between the buyer and the seller. That has nothing to do with you. Here's where it has something to do with you, though. If you're not turning over the escrow, if the buyer cancels legitimately and you're not turning over the escrow because you're waiting for the seller to get the escrow, because then you're going to get a percentage of it as a commission on the failed sale, then you're looking at liability there as well. Okay. Escrow agents are supposed to be neutral. And in fact, when we deal with law firms that are escrow agents, we stress that point, that while you are representing the other side, you are not, as the escrow agent, you are not able, you can't just take their instructions. And that goes for real estate agents too. If you're the listing agent, you can't take instructions on the escrow solely from the seller. You have to take the buyer's instructions as well. When I'm the escrow agent, I make sure that my client understands that I can't release escrow unilaterally. I need escrow to be released by both parties. I tell other attorneys, same thing. You can't release escrow unilaterally. It has to be agreed to by both parties. And I've had issues with attorneys who've said, "Well, I want the escrow release," and I'll say, my client disagrees, and we're going to have to argue it. Just because one person wants escrow release doesn't mean that they're going to get it. And some people think they will because of the relationship between the escrow holder and the client. That's important to distinguish and make sure that people understand. Just because you are holding escrow does not mean that you take orders from your client. All right. Just because you are holding escrow does not mean you take orders from your client. Doing so is another place where realtors can get into a lot of trouble. Doing so is another place where realtors can get sued and can actually face damages, right? It's one thing to be sued because you're holding the escrow, and that's going to just be, I'm holding the escrow, they're suing me as what's called the nominal defendant. I show up, I handle the lawsuit, and then we move on. This is going to be a much bigger issue. This is going to be much more of a now what kind of situation. Is there liability to you? Is there something that you were doing that you need to not do anymore? That you're holding the money that you're supposed to be giving it away, that you're supposed to be sending it off. That is 100% a possible liability issue for realtors. Another big issue that I want to talk about, and this one's really, really interesting, I think. Car insurance is something that I talk to a lot of agents about, and I'm gonna spend some time on this as well. Nobody thinks about this. Everybody gets a policy and they call it a day. But if you have just a personal coverage plan, Geico or Progressive, or even from a regular from an insurance broker, if you have a personal coverage plan, not a business plan, if you get into an accident, you may not be covered. And that's going to really run the risk of you ending up in court here. One, to try and defend yourself, but against any loss. But then two, trying to sue the insurance company to try and get them to cover you. They don't cover business driving. Business driving is when you're using your car for business. Now, if you're just going to the chamber for a networking event, that's not what they're talking about. But if you've got a client in your car all day and you're driving around all day long with the client in your car, showing them house after house after house, that's business driving. All right. If you're driving around, going from house to house, that's 100% business. Here's the thing: if you have magnetic sides on your car, magnetic signs on your car, they may decide that counts as business driving. There's a lot of insurance companies and other places as well where they say no non-commercial use only. They'll ding you for that. If you have the magnetic signs on your car, you 100% can be dinged for commercial driving when you are trying to drive your car. Best practices on something like that is generally to take the magnets off, unless you really at times when you don't want to be driving commercially. But that is something to be really considerate of, and to consider, again, making sure you have the right insurance. Last week we had Mackenzie Redding from Goosehead on, and we were focusing on homeowners insurance. We didn't get into this at all, but it's a big issue, and it's one that is worth talking about with an insurance person. It is definitely one that's worth talking about with an insurance person who knows their stuff, who knows what they're talking about, to try and get them to explain to you, to make sure try and get them to review your policy and make sure you've got the right policy for what you need. Okay. I want to stress this again because there's a lot of accidents in Orlando as people are driving around. This is a big liability hole here that a lot of people don't think about. I don't want people to be scared of driving. I don't want people to be worried about what driving is going to look like, but I do want them to know what this is. All right. So that wraps up for me. I don't see any questions in chat. I don't know if there are any questions today. I'll open the floor up to questions, but let me again do my pitch. Focus occupancy agreements on May 9th. Again, we'll probably end up also getting into appraisal contingencies. These are really going to focus on why, what you should be looking at if you're using the post-occupancy addendum or the appraisal addendum, or versus just something in the additional term. I will get some contracts with additional terms as well to try and use. June 13th, what realtors need to know about trust, powers of attorney, and ladybird deeds, again with Matt Rosenthal. That's going to be, I think, a really great program. And also on July 11th, social media marketing with Michaela Walker. We're also doing other programs. If you have requests, if you have something you want us to cover, let us know. We're happy to look into it. If you want a private class for your team, let us know. We're happy to try and provide that. We are doing office hours again. We don't have a date yet for May, so watch our Facebook page. We'll probably be doing that again in May or June. Again, just something to watch out for. That's where I just open up a Zoom room and keep it open for an hour or two. I'm looking at bringing guests this time as well. We had an insurance guy hop in for a little while last month, or this past month in April. Might try and get a mortgage person, might try to get, again, another insurance person to hop in where they can answer questions as well. The point is not to come in with an agenda, but to come in and just answer questions as they arise. All right, so I'll open up to questions, but I'll stop the recording here. Thank you all very much for joining us. Look forward to seeing you at one of our future events. Registration for the next event will be up later this afternoon. This video will be up probably tail end of this week. Thank you all and have a wonderful day.